Friday, the 30th of June, U.S. Supreme Court strikes down race-based college admissions. Welcome to Global Voice. The United States Supreme Court has ruled that race can no longer be considered as a factor in college admissions. The landmark ruling upends decades-old U.S. policies on so-called affirmative action, also known as affirmative action. It is one of the most contentious issues in American education. Affirmative action was first introduced into politics in the 1960s and has been advocated as a measure to increase diversity. U.S. President Joe Biden said he strongly disagreed with Thursday's long-awaited decision. "We cannot allow this decision to be the last word," he said. "Discrimination still exists in America. This is not a normal court," he added, of the 9 judges, who are divided ideologically between 6 conservatives and 3 liberals. Education Secretary Miguel Cardona told BBC News the court took away a very important tool that university leaders use to ensure diversity on campus. What it did not remove, however, is the intent to ensure that our universities are made up of wonderfully diverse students, just like our country. He continued, adding that the White House will issue guidance to universities with instructions on how to legally maintain the diversity. The ruling covered 2 cases related to admissions at Harvard and the University of North Carolina, UNC. The court ruled 6-3 against UNC and 6-2 against Harvard. The judges sided with an organization called Students for Fair Admissions, founded by legal activist Edward Blum. The group argued in court last October that Harvard's race-conscious admissions policy violated Title VI of the Civil Rights Act of 1964, which prohibits discrimination based on race, color, or national origin. Chief Justice John Roberts wrote, "Too many universities have mistakenly concluded for too long that the touchstone of an individual's identity is not challenges overcome, skills developed, or lessons learned, but the color of their fur." The majority opinion of him said that the policies of UNC and Harvard were well-intentioned. The decision noted that universities should not be barred from considering an applicant's discussion of how race affects his or her life. But Judge Roberts wrote, "Harvard's admission process is based on the pernicious stereotype that a black student can usually bring something that a white person cannot offer." Justice Clarence Thomas, the nation's 2nd black judge and a conservative who has long called for an end to affirmative action, agreed. He wrote that such programs were patently unconstitutional. "The self-professed rectitude of universities does not give them a license to discriminate based on race," he said. Among the dissenting liberal justices was Ketanji Brown Jackson, the first black woman appointed to the bench. She said the decision was truly a tragedy for all of us.